So after completing conditions and warranty, our next topic is rights and duties of a buyer. So as per the law or the Sale of Goods Act, there are certain rights and duties that has been mentioned in the law or the act that is belonging to the buyer. First, let's study what are the different rights of the buyer. The first one, right to have the delivery as per the contract. Now, the first right for the buyer is to take the delivery of the goods or commodities. However, the seller or the buyer has agreed upon in the contract, right? Agreed upon the contract either by a package or by through roadways or whatever that is. However, the delivery of goods have been agreed upon, the buyer has the right to take the delivery as per the contract, as per both have agreed upon earlier. Second, right to reject the goods. Now, in case if the seller has to send the buyer a larger or a smaller quantity of goods than he ordered, the buyer may reject the whole, accept the whole, or accept the quantity to be ordered, or you can reject the rest. So basically, in short, now if buyer has ordered only 100 kgs of certain product or a commodity, right, and the seller is sending 200 kgs of that product, now, in that case, the buyer can reject full whatever the goods have been reached him, entire goods he can reject, or he can keep only 100 goods for which he had ordered, for which he had paid the price, and the rest 100 kgs of goods he can return it back or reject the goods, or he can reject the entire lot of goods and give back to the seller. Is that clear? The second right of the buyer is to reject the goods. Whatever is agreed upon only must reach the buyer. In case it is reaching lesser than the, if he has ordered for 100 kgs and if the seller is sending him only 75 kgs, then the buyer can reject that goods. He can demand for the exact amount of quantity agreed upon. Okay, neither less nor more. How much ever is agreed upon, for how much ever price the buyer has paid or consideration given to the seller, equal to that the quantity of goods must reach the buyer. Third one, right to repudiate. The buyer of the goods has a right not to accept delivery thereof by installment. Now, in case we have agreed upon to deliver the goods on particular date, all the quantity of goods on a particular date, but if the seller is telling no, I will not give you at one shot, but it was agreed upon one day the entire delivery of goods would be given, but on the date of delivery the seller says I'll give it on installment basis. I can't give it on one shot, but I'll give it on installment basis. On this note, the buyer has the right to repudiate, means what? Reject or refuse the entire contract. No, I don't want an installment basis the delivery of goods. Instead, I wanted one shot delivery to my godown. Is that clear? That's the right to repudiate. Number 4, right to notice of insurance. Now, if the goods are sent by the seller to the buyer, maybe let's say for a sea route, right? Sea route, then the buyer has a right to be informed by the seller so that he may get the goods insured. Because when we are selling in seaways, right, anything can happen in the sea route, right? The ship may get damaged, or the goods may get dissolved, or anything, goods may get damaged in the water and everything is lost because buyer has already paid the consideration for the price. So buyer has the right according to the act that I need to be insured. I need to be firstly priorly informed. Second, the goods must be insured. In case I lose it, I need to get a compensation. Reason being, buyer has already paid the consideration or the price of the goods to the seller. So what is the fourth right? Right to notice of insurance. So buyer should be informed that the goods are reaching to him in the form of sea route, and that he may get the goods insured. Number 5, right to examine. The buyer has a right to examine the goods which he has not previously examined before he accepts them. Now, just because maybe it's a distant transaction between the buyer and the seller, right? Just maybe based on the samples, he might have just gone through and finalized the agreement between the purchase or sale of goods. Buyer has not actually examined the exact goods what he is going to receive. So right when it reaches his go down, buyer has every right to examine the goods that the seller has sent him. Okay, he has the right to examine whether or not it is according to the agreement, the price, or the quantity, or the color, the size, the quality, the working function. All of these qualities can be examined by the buyer right when the goods are reaching him. Okay, is that clear? So in case the buyer is not happy with the goods that has reached him, let's say there is some kind of default in the goods, there are some kind of damages in the goods, then the buyer can send the goods back and claim the damages. Is that clear? He can examine, if he finds any fault with the goods, he can send it back and claim for the damages, or ask him for the entire new lot as agreed upon in the contract. Is that clear? Number 6, the sixth right of the buyer is right against the seller for breach of contract. We already looked at what is a breach of contract. It is cancellation or termination of contract. Number 1, suit for damages. Seller wrongfully neglects or refuses to deliver the goods to the buyer. So the seller basically does not take enough precautions or enough being careful about the type of goods that the buyer has asked for in the first case, and accordingly pack the goods and send it. So he was negligent. He was negligent in checking the goods and giving. So he has given the wrong goods, or the goods which has not been ordered for has been sent across to the buyer. So what does the buyer do? He refuses to take the goods, or he refuses to uh, basically accept the goods as it is, because it was negligently sent or wrongfully sent. So therefore, what can the buyer do in this case? He can suit for damages. Okay, because it was not as upon the agreement, the buyer can suit for the damages. Second, suit for price. If the buyer has paid the price but goods are not delivered, he can recover the amount paid. On the first case, it was the wrong goods. Yes, he delivered. It was due to negligence, or he delivered the wrong type of goods. He can claim damages. But under suit for price, the entire price or the amount of money, whatever the buyer has paid as consideration, can be asked or can be sued for the entire price of the contract. Let's say the entire contract for rupees 1 lakh. Okay, rupees 1 lakh the buyer can claim from the seller. Why? Goods are not delivered. Price is paid, but then goods are not delivered. So instead, what does the buyer do? He tells, please give me back the money or the consideration that I have paid for the goods. The third one, suit for specific performance. The buyer can sue the seller for specific performance of the contract to sell. Now here we have observed that under the breach of contract, there was a certain condition called breach for specific performance. If you can remember, we spoke about companies providing furniture to another company, right? Furniture supplier providing the furniture to one of the dealer, whereas it was on a specific day. It was a special inauguration maybe of the shop, and they wanted the furniture. The seller or the supplier priorly knew he had to deliver that particular furniture on that particular day without fail. Right? It was agreed upon that it's a very important day and not to miss because of the importance of that particular day. Right? That means it was specifically mentioned to the seller or to the supplier to deliver the goods on a specific date, on a specific time. When that has failed, or maybe he has supplied but on the wrong type of goods, not to be ordered, not which is specified, then the seller can be sued for specific performance. Next, suit for breach of warranty. Now here we are looking at warranty. Now if you can look at when we discuss about conditions and warranty, we discussed also when can the condition be treated as warranty. We discussed three different situations over there. First, it was a breach of condition, but instead of returning the goods, he just asked, you just pay me the damages. Second, a situation we looked at where buyer assumes or buyer decides that he chooses the uh, breach of condition as breach of warranty. He himself chooses it at breach of warranty and claims damages, correct? Now one such here is suit for breach of warranty. Now warranty and condition, hope you guys know the difference because last class we have studied about it. Condition is the main stipulation, main purpose of the product or the commodity that you're selling. On the other hand, what is warranty? Warranty is just a collateral to the main condition, right? Now, as I told, if I am ordering a car which has to give me a mileage of 20 kilometers per liter of petrol, then the seller is going to deliver me, but I'm going to mention that I need a black color car. Okay, the main condition is what for me? The car must run 20 kilometers per liter. But then I have another added condition, that is the color of the car. Now, yes, he has delivered the car to me. I have paid the price to him. But when the car reaches and I drive it, the car gives me 20 kilometers per liter. Yes, the condition is met. But then the color of the car is white. Now that is called as breach of warranty. Okay, it is not exactly the main condition of the product is being fulfilled. The main condition of the asset or the commodity is completed, is fulfilled. But just the additional, that is the collateral warranty is missing or is damaged. Got it? So here in this case, the buyer has the right to sue for the breach of warranty. That means what? If it is a breach of condition, what did we study? We can claim for the termination of the contract itself. Condition is not met. If my car is not giving the mileage that I've asked for, then why purchase that car? Correct? So I'm going to cancel the entire contract. But if the color of the car has changed, that does not have to mean that I need to cancel the agreement over here. I can just claim the damages. Likewise, here as a right of a buyer, he can only claim the damages if there is what? Breach of warranty. Is that clear? Next, repudiation of contract before due date. Now, when the seller repudiates the contract before the date of delivery, the buyer may either treat the contract as substituting and wait till the date of delivery, or he may treat the contract as rescinded and sue for the damages for a breach. Now, repudiate means what? Cancel, correct? Cancel or reject or refuse. Now, who is refusing? The seller is refusing the contract before the due date. Let's say due date is on 10th. Now, today the date is, let's say 5th. Now, today the seller is refusing to fulfill the promises of the contract. So, the buyer may either wait until the date of the contract and sue for the damages, or on that particular day itself, the buyer can sue him for the damages. Is that clear? Repudiation of contract before due date means the buyer, whenever the seller has rescinded or repudiated, on that particular day he can sue him for the damages, or he can wait until the date of the agreement or contract. On that particular day, of course, buyer is ready to perform his obligation, but the seller is missing. Seller is defaulted his promise or obligation. Therefore, buyer can sue him on the date of the contract or agreement. Got it? The last one, suit for interest. When the seller breaches the contract, as a result, the price has to be refunded by the buyer. Buyer has the right to claim interest on the amount of price refunded to him from the date on which the payment was made. Now again, in case the seller again breaches the contract, another condition here, seller is terminating the contract here. As the result, the price has to be refunded to the buyer, correct? Because buyer has already paid the consideration of the contract or of the commodity to the buyer. Now, if seller is not willing to sell his product or commodity, what does the seller do? Seller has to refund the amount of consideration back to the buyer. So, buyer in this case has the right to what? Claim interest on the amount of price refunded to him from the date on which the payment was made. Now, let's say in this example we told 10th was the agreement date, okay? On 5th, today is 5th. So, 5th the seller is telling that he is not going to perform the contract. But I made the payment or consideration for the goods when? On 1st of December. So, for the next 10 days from 1st December to the 10th December, Act says, or the Sale of Goods Act says, the buyer has the right to sue him for the interest also. Is that clear? The buyer has the right to sue him for the interest also. Now, if he has not paid the price, for an example, then that option does not come for payment of interest. Only for damages the buyer can claim. Because why? He has not paid the consideration in the first place. But in this example, we consider that he has paid the price on 1st December and the seller says on 5th December that he is not willing to complete the contract or fulfill his obligation in the contract. Therefore, the Act says, the Sale of Goods Act says, the buyer has the right to claim interest. From which date? From the date on which the payment was made. So, from 1st to 10th, for 10 days he may charge an interest and then take the remaining principal amount back to him. Is that clear? So, these are the different rights of the buyer. Right to have delivery as per contract, right to reject the goods, right to repudiate, right to notice of insurance, right to examine, right against the seller for breach of contract, suit for damages, suit for price, specific performance, breach of warranty, repudiation of contract before due date, and suit for interest.